So hi everyone and welcome to the third Crimmigration Law Talks webinar. Today we talk about crimmigration and critical legal theory. So really the intersection of criminal law with immigration law and how this concept has been explored through various disciplines by academics of diverse backgrounds and how it has been challenged. It has opened the way for new ways of thinking and new avenues. So without further ado, we are going to start with Jose Angel Brandariz, Associate Professor of Criminal Law and Criminology at the University of A Coruna, Spain, Magdalena Kmak, Professor of Public International Law at Akademi University in Finland, and Kate Ogg, Associate Professor of Law in Australia at the Australian National University. So Branda, the floor is yours if you want to start.
Okay, thank you so much. I hope you can see me and hear me well. Apparently my internet connection is not particularly stable. Oh, thank you so much to Martje van der Woude and Camille Lefebvre for inviting me to be here, sharing with you a number of thoughts on crimmigration law and the critical legal perspective. I'm gonna share my screen with you because I got a PowerPoint and yeah, I hope you can see it well. Right. So let me put this in presentation mode. And I'm going to go straight to the point because we have only 10 minutes, right? Crimmigration and border criminology scholars have long emphasized that crimmigration practices raise a number of legal concerns. This literature stresses that in regulating immigration detention and deportation as non-penal measures, crimmigration law prevents non-citizens from being protected by criminal law safeguards. And consequently, scholars working in this field contend that immigration enforcement measures should be considered punishment and treated as such. And in addition, border criminology scholars claim that the massive insertion of non-citizens into some global North criminal justice system is resulting in the consolidation of dual penal systems. In the framework of this emerging punitive scheme, penal practices are determined by citizenship criteria so that penal welfareism measures are exclusively applied to citizens. So evidently, the greater or lesser significance of this last point regarding the dual penal system is dependent on the extent to which penal welfareism practices are still in force in the corresponding jurisdiction. Given the variations of democracy characterizing statecraft in Europe and ultimately conditioning penalty, the gap dividing this alleged dual system is much narrower in some countries than in others. Still, my main point today has to do with reflecting on the aforementioned conclusion on the legal consequences of the penal, non-penal nature of crimmigration practices. So this point, in my view, is particularly important to challenge crimmigration policies from a critical legal perspective. In fact, this conclusion on the legal consequences of the penal, non-penal nature of crimmigration arrangements is especially helpful to dissect crimmigration arrangements emerging across Europe, in which criminal justice agencies are using immigration enforcement measures to circumvent the lengthy and allegedly rights-based criminal law procedures in managing unwanted non-citizen groups. These arrangements show that instrumentalism concerns are taking center stage in the field of crimmigration practices. In the old continent, these instrumentalist practices can be seen, for instance, in the deportation of Eastern EU nationals from Western European countries, in various policing strategies targeting undocumented non-citizens such as Operation Nexus in the UK, and in counterterrorism deportations frequently applied in a number of countries, such as, among them, Cyprus and Italy. But having said that, the aforementioned conclusion fails to come to terms with a notable variety of crimmigration practices across Europe and elsewhere. More precisely, it falls short of grasping the markedly diverse ways in which criminal justice measures and immigration enforcement measures are combined in more or less symbiotic ways. Comparative explorations on crimmigration policies are urgently needed because they may lay bare the legal implications of this diversity. Some crimmigration phenomena may assist in illustrating this point. So I'm going to mention essentially three different crimmigration law aspects. One, in some countries, unwanted non-citizens are not prevailingly handled by the immigration enforcement system, but by the criminal justice system itself. Specifically, the criminal justice system is still playing a pivotal role in tackling and documenting mobility. In fact, irregular migration crimes are rarely used in certain jurisdictions, such as the UK, but they are widely prosecuted in other countries, such as the US and Italy. You can see it here. This is the average number of irregular migration crimes being applied per year in the UK, that stands in stark contrast to the number of crimes prosecuted in France, Germany, Italy, especially the US. So second point, the preference given to immigration enforcement measures in managing so-called criminal aliens is generally detrimental for non-citizens in terms of legal safeguards and protections. However, in certain cases, this scheme may actually be beneficial for non-citizens because deportation enforcement rates are extremely low in some jurisdictions, such as in the case of Europe, the Czech Republic, Belgium, France, Italy, and Portugal. A third point, in addition, the ways in which penal measures and immigration enforcement measures are legally articulated show significant cross-national differences. In some countries, penal measures are substituted with immigration enforcement measures before being completely served. Some cases mentioned above, especially the enforcement of deportation orders in the counterterrorism field, are a clear manifestation of this model. And more generally, the Chilean legal order, which is a forerunner of crimmigration policies in South America, is a patent example of the ways in which immigration enforcement measures lead to bypass and ultimately cancel penal measures. By contrast, in other jurisdictions such as Norway and the UK, these two types of measures operate in a cumulative way, since penal sentences have to be served before enforcing the corresponding deportation order. Okay, so moving into the conclusion, in sum, crimmigration and border criminology studies should decidedly engage in cross-national analysis to grasp the varied legal implications of crimmigration arrangements. The multi-scalar nature of border control policies ensures that the diversity presented here is not destined to be a short-lived phenomenon. As a starting point, we may consider a number of indicators revealing these variations, such as the scale of national immigration enforcement systems, that in the case of Europe shows us that the UK, Germany, Greece, France, Spain, and Poland are on top, leaving well behind many other European jurisdictions. Deportation rates that show us that the impact of deportation practices on so-called third country national communities, I mean non-citizens communities living in Europe, is, markedly different. You got on top Eastern European countries, and by the right side of this spectrum, you can see certain Southern European countries in which deportation practices are not having a significantly relevant impact on non-citizen communities. We may consider as well deportation enforcement rates that show us that actually a number of countries are much more effective, speaking about Europe, much more effective in enforcing deportation orders than other Southern and Eastern European countries. And we may want to consider as well, especially actually, the index representing the over-incarceration of non-citizens, which is particularly useful to understand to what extent either immigration enforcement measures or penal measures are taking the lead in the crimmigration sphere. So I'm going to leave it here because we were expected to talk for just 10 minutes. Thank you so much for your attention.
Thank you so much. Magdalena, I don't know if you are ready, but we can pass the mic to you.
Yes, I'm ready. So thank you so much for the invitation to take part in this seminar. I'm so excited as well. I've been also looking forward to this panel. And I'm going to approach crimmigration from the perspective of mobile law. And I wanted to address the relationship between crimmigration and critical legal theory from the perspective of mobility studies. That's what I've been working on recently. So what I will do today, very briefly, I will focus on three aspects of this approach. First, I will discuss what I understand by mobile law. Then I will discuss what is the role of crimmigration in this approach and how I see it. And third, I will discuss possible ways forward by bringing in the concept of resistance. And before I will do that, I want to apologize for my voice, which has been gone for the last week. And it's getting better, but it might be that it can, it will be gone at some moment again. So apologies for that. So let's start with law and mobility. In short, what I'm proposing is a shift in perspective on law from the static to mobile. And my inspiration comes from Thomas Nail's work, in particular, the books, The Figure of the Migrant and Being and Motion. And according to Nail, either one begins with stasis and claim that real motion is an illusion, or one begins with flow and treats stasis as relative or folded forms of movement. So such perspective allows us to see both the nation state and the law, not as a monolith, but as only temporary stability, or even reveals a permanent instability of legal concepts. So if we apply a mobile lens to law, we can see that its universality crumbles. In the context of migration law, we can see first that the mobile subject is differently positioned and able to exercise their mobility in different ways, depending on their citizenship, gender, class, or race. And here, the universal subjectivity constructed with the help of law materializes itself concretely through this differential mobility. So in other words, law and jurisprudence constructs differently mobile subjects depending on who and how is moving in contemporary globalized world. Hagar Kotev, in her Genealogy of Orderly Mobility, explains this differentially embodied mobility that we continuously observe by focusing on the relationship between construction of universal subject and coloniality. In her work, the emergence of liberal European subjectivity is rooted in freedom, understood as orderly movement, and is juxtaposed with disorderly movement of colonial others. And in the modern nation-state machine, this distinction is really much visible, and it's perpetuated through what Thomas Spijkerboer calls the global mobility infrastructure. As he shows, the infrastructure serves the politics of no entrée, or by speeding up some desirable mobilities and slowing down or stopping undesired mobilities. So the modern nation state needs and utilizes this disorderly moving others for its own construction and perpetuation through monopolization of violence and the legitimate means of orderly movement. And here comes the link with crimmigration, how I see it. And from this perspective that I just outlined, I thought that Katia Franco's crimigrant other concept is quite useful because it's for Katia Franco's, it serves as constitutive other for the nation states towards whom this violence then can be directed. So the crime migrant other functions here as externalization of discomfort and blame for this fundamentally differential mobility, which is rooted in this coloniality, modernity background of contemporary nation state and legal systems. And Katia Franco shows that how the social production of crime migrant other serves to turn issues of global privilege into issues of morality and the maintenance of the moral order. In addition, the constant failure of the migration system based on violence prompts further criminalization of migration and further violence that serves the nation's, what I call the nation state machine, and fosters its continuous reproduction through leaking of migration law into other areas of law, such as criminal or citizenship law. And I think Branda has shown some of the examples. It's more visible in some states, but less visible perhaps in other states. But at the same time, the alter ego of crime migrant other is a vulnerable subject who is a focus of more and more externalized humanitarianism. So the consequence of this distinction is, I believe, that this orderly mobility, which is based on liberal subjectivity, encompasses and allows for quite effective human rights protection, what I call mobility as a right. And in case of this shadow infrastructure, on the other hand, that is based on the dynamics of criminalization, securitization, and vulnerabilization on the other hand, the access to rights depends on how deserving or undeserving the mobile person is for having their rights protected. And in the crime migrant other book, Katia Franco shows this differential treatment, for instance, in the need of infliction of higher level of pain and harsher condition in her study of detention regime of Eastern Europeans in Norway. And she quotes one of the police officers saying, for Eastern Europeans, prison is like a hotel where they get a daily allowance. So this leads to differential human rights protection. And whereas in the case of orderly mobility, human rights operate in principle according to their purpose and design, they do not necessarily apply to disorderly mobility, as has been shown in recent cases at the European Court of Human Rights, such as NDNNT versus Spain, or very recently decided AA and others versus North Macedonia. We can see here that where certain mobile persons can claim their rights based on the human dignity, the legal redress is very limited in case of disorderly, irregularized mobility considered as a violation of law. So the crime migrant other, or whatever we decide to, whatever kind of concept we decide to use here. So the person's rights are based on the deservingness, which in principle means orderly movement. So my third point is how to proceed from here. And understanding the construction and the role of orderly and disorderly mobility that is rooted in coloniality and enshrined in the differential liberal subjectivity allows us to look for possibilities of resistance. And within the law and mobility framework, I approach mobility not only as a right or a violation of law, in other words, the way how law affects mobility, but I also study the impact of mobility on law. So one of the aspects of this is a mobility as a resistance to law. So the question is, how to resist the law, the lack of universality of which is revealed when we focus on material and embodied mobility of racialized, gendered, or classed person. And I look into mobility as resistance from within and from outside the law, which is nevertheless interrelated. So very briefly, I give you 3 examples just to leading toward the conclusion of this short intervention. I wanted to give you 3 examples inspired by law and mobility perspective. The first one is to take further Ben Golder and Peter Fitzpatrick law as resistance approach, and they focus on law as mobile and contingent and constantly oscillating between openness and closeness. This leads to treating mobility as a quality of law, in particular in the context of jurisprudence. And the work of Olivia Barr and Alexandre Lefebvre is very inspiring here. And the judge, for instance, in the context of jurisprudence, the judge is constantly on the border between the 2 kinds of movement, simultaneously enacting a closed legal system and expressing its creative and open whole that can encompass areas or situations or kind of concepts that hasn't yet been included. Then the second approach is acting as if, enshrined in the work of Davinia Cooper. And for Cooper, acting prefiguratively as if allows to acknowledge already existing multiple realities and acknowledging that law is not able to narrow them down. It also allows for thinking about alternative laws and alternative research projects. And the third one is focusing on mobility as a production of legal knowledge, where the focus is on the one hand on knowledge stemming from the experience of law and legal procedures, and on the other way, where law and legal knowledge and research is produced by migrant, exiled, and displaced legal scholars. And I've been focusing on this topic for a couple of last years, studying the role of experience for the work of legal scholars exiled and displaced in history and currently. And another example is the project at the ANU that Kate here is involved in on rewriting jurisprudence from the perspective of refugee and migrant lived experience. So to conclude and raise points for further discussion, I am very much interested in any possible examples of mobility as resistance to law. I think also to what Brand have been saying, that would maybe require studying this very, localized ways in which, for instance, deportations are being enforced and how they are being challenged, for instance, in the countries where the level of expulsions are very low. And so that's the first question that I would pose to the panelists and to the audience here. And then maybe should we make an effort or have a joint effort of gathering examples of resistance to challenge this monolith on law as much as we can? And the second question that I'm having and I want to throw on you is based on the kind of an idea by Alexandre Lefebvre that the movement of law and jurisprudence always responds to the time and the general will of the society. And this affects direction towards which the law moves. So can we approach the legal regulation of the position of refugees fleeing Russian aggression and war in Ukraine? Does this provide a proof of such momentum where significant societal change happens, or are we going to be back to normal after the crisis is over? Thank you so much, and I'm really looking forward to other talks and the discussion.
Thanks so much, Magdalena. So Kate, you can have the floor.
Thank you, Camille, and thank you everyone for inviting me to be part of this panel. And there's actually a lot of intersections between my talk and both Magda and Jose. So I first engaged in Crimmigration scholarship in 2018 when I was asked to be part of the first Australian project on Crimmigration. So at the time, Crimmigration wasn't part of the Australian scholarly or legal lexicon, which is a bit surprising when you think about it as a former penal colony. Our infamous offshore processing policies, you would think Australia would be sort of the archetypal case study for Crimmigration. So I was brought onto this project to do, and I was asked to do a feminist examination of Crimmigration in Australia. That was my brief. And I think that was because I had just finished up a project doing a feminist examination of Article 1F of the Refugee Convention. So that's the article that excludes people from refugee protection on the grounds of criminality. So diving into the Crimmigration literature, I've represented it diagrammatically for you. See if I can share my screen with you, because it was really, really quite fascinating. So on the one hand, can you see that?
Yes.
Yeah. See if we go. Why is it not working? Slideshow from current slide. There we go. On the one hand, so you've got Crimmigration scholarship, which my view, and I don't think this is a controversial one, was really developed without any reference to gender, certainly without any reference to the very flourishing subfields of feminist criminology. And it had really, I think, continued to develop in quite that gender blind manner. Now, that doesn't mean that there was not or is not research on gender, women, crime, migration. Of course there is. There's a really robust field covering those themes, actually sort of, I think, really led by Australian feminist criminologists. But that scholarship was not in any way engaging with crimmigration. So it wasn't using the terms, the ideas, the rhetoric or anything. So it's quite interesting that you've got these two fields of scholarship developing in silos, even though you would expect to see a lot of overlap and conversation between them at least. But there was a 2013 article by Alison Gerard and Sharon Pickering making a call to feminist legal scholars, criminologists to engage with this concept of crimmigration. And there were two publications at the time which I would have thought, okay, they've taken a step in that direction. And while I do think these are the articles by Hartree and Dingman referred to on the slide, I think these are important contributions, but as a feminist scholar, they made me a little bit nervous. And that's because I think what they were doing is what's often referred to as add women and stir. So what that means is taking a theory that's been created without any reference to gender, such as crimmigration, and then applying it to women. So my view is, if we were really going to answer this call by Gerard and Pickering, if feminist legal criminological scholars were going to engage with crimmigration, there first had to be a sexing of crimmigration theory. So that is an unearthing of the gender biases assumption in crimmigration scholarship and the terminology used in that scholarship. So I said to the leader of the Australian project, I said, I can't do a feminist examination of crimmigration in Australia. I've got to use the Australian example to do a feminist examination of crimmigration. So that's what the crimmigration theory. So that's what I ended up doing. And so the purpose of my chapter that I produced as part of this Australian project was simply, it was a really humble one. It was just to start the conversation. So start the conversation about sexing crimmigration theory, and that's really core feminist legal work. And it's really important work. For those of you who do have a background in feminist criminology, you'll know that when theories are developed that are, gender blind, and then they're applied, so theories of crime, criminalization, victimization, they're applied in the real world, they often have really harmful consequences, and harmful consequences for people of all genders. So, in the chapter, I look at stories of women who came to Australia seeking asylum, but who were at various points of the journey treated akin to a criminal offender. And I wanted to know how what was their experience of the intersections between immigration and criminal law, and did this map onto the way that relationship is often theorized in crimmigration scholarship. And my ultimate argument was that crimmigration theory ignores and misrepresents many women's experiences of the relationship between immigration and criminal law, but nevertheless that feminist perspectives can certainly enrich aspects of the crimmigration phenomenon. And I really in particular wanted to interrogate the fundamental proposition of the crimmigration thesis, which is that criminal law and immigration law are no longer separate. They have melded, they've merged. This amalgamation manifests as a leviathan, and it's a crisis, or at the very least, it's troubling. And I explore this mainly through the story of a woman who is only known to us as S99. So if you don't know her story, she's a woman, she was from an African country, we don't know which one. She left her first husband because of domestic violence. She married again, but her second husband accused her of adultery, and that was a crime punishable by death in her country. So and this is the quite chilling words of the Australian Federal Court. They said she sought refuge in Australia where she thought she would be safe. She was sent to Nauru. She was placed in immigration detention. Now, she said immigration detention on Nauru was tough, but secure. Now, she was eventually released from immigration detention, partly because of advocacy. And this was advocacy I was in part of, advocacy to end immigration detention in offshore processing centres in Nauru and Papua New Guinea. And so she was placed in open living arrangements, and she found these incredibly unsafe. She asked for security, additional security, a number of times, and she was ignored. She left her house one day to use telephone, and she had an epileptic fit and became unconscious. And she was raped while unconscious and became pregnant as a result of the rape. Now, she wanted to terminate the pregnancy, but it wasn't possible to do this in Nauru because it's illegal to have an abortion in Nauru. So she wanted to come to Australia, but the Minister for Immigration refused and instead transferred her to Papua New Guinea. Now, abortion is also illegal in Papua New Guinea, and her view was that because of her medical conditions, it wasn't appropriate for her to have the medical procedure there. So she made what I think was an incredibly courageous decision and started court proceedings against the Australian Minister for Immigration in the Federal Court of Australia, pleading Australian tort law. So my looking at her circumstances and the various legal responses to her circumstances, I argue that it indicates that at least in this Australian context, criminal and immigration law have not merged at all. In fact, they remain stubbornly disparate. And the fundamental disjunctures between the two areas of law are reflective of a lack of concern about violence against women, both at the international and domestic level. And I'm happy to step through that argument for anyone who's interested. But the other point I make, and this is a more controversial one, I think, most controversial one in the paper, is that the melding of immigration and criminal law, when it does happen, shouldn't be always seen as troubling or a crisis. So this goes back to S99's own evidence before the Federal Court of Australia that immigration detention was tough but secure. So we shouldn't always see the increased use of police-like powers in immigration contexts as, we shouldn't always view that pejoratively. And I make this argument very carefully because I'm of course aware of some of the backlash against feminist criminology, that feminist criminologists, some have been accused of playing into law and order politics, as of course that label casts real feminism. So I'm aware of that, but coming at this really more from a refugee and forced migration background, you know, there is acknowledgement that in some contexts refugees need to be protected from other refugees or people in the host community. This is where I think my paper very much intersects with Magda's ideas. I think conceptualizing crimmigration as a leviathan, I mean, the term leviathan really evokes this idea of this overwhelming system of law and policy being imposed on refugees, and it really focuses on what the host state is doing. And what it ignores, I think, it takes focus away from the ways in which refugees and migrants are themselves shaping these laws, in particular through acts of resistance and disputation. One of the most really frustrating aspects of crimmigration scholarship for me is the personification of law. Like, a lot of crimmigration scholars talk about law shifting and moving and changing. Law only ever changes through human agents. And the way, so I think what S99's story so brilliantly shows is that the ways in which refugees are really significantly shifting what we may call crimmigration law. So her decision to bring a case, a very brave decision to bring a case in the Federal Court of Australia against the Minister for Immigration, she was attempting to come to Australia to be able to have the medical procedure in Australia. This jurisprudential precedent that she created has literally saved lives. It also created a political and legal explosion in Australia, almost upset a federal election. So I'm really happy to talk about that more, but if you're interested, but I think to have more feminist scholars engaging with this concept of crimmigration, it's still an open question of whether we need or want this. But I think one positive aspect will be a move away from this concept of migrants and refugees as sort of victims of these overpowering forces, and more of a focus on highlighting acts of agency and resistance. The one area where I think crimmigration scholarship really nicely intersects with feminist theories on migration, crime and gender is Sturm describes crimmigration law as having, and I quote, the ability to metamorphose, end quote. And this immediately made me think of some of, for example, Sharon Pickering's work on the personalization of borders. So I think where feminist sort of criminology can really contribute very richly to crimmigration is to understand the malleable nature of crimmigration and unearthing the gendered aspects of crimmigration law's fluidity. Now, questions for that I think would be really interesting to explore. Do feminist theorists really need to engage with crimmigration theory? I think there needs to be more of a section with crimmigration theory. Doesn't need to be engaged with when there's already this really rich literature on women, crime, migration. I think having a look at some of Diane Otto and Hilary Charlesworth's scholarship on the position of feminist scholars in international law might create some nice parallels, a nice sort of food for thought, because they sort of reflect quite critically on the position of feminist scholars in international law. So that might be something to consider. Something that I have discovered recently, it is sort of noticed on sort of different projects, I've noticed in the UK and Australia, increased jurisprudence on criminal deportation of refugees. And I've just got some references here for you. Please feel free to cannibalize my footnotes if you're interested in this particular phenomenon. So I think this as a phenomenon needs to be explored a bit more, but I think in particular, we really need to have an upfront, sensitive, nuanced discussion about the gender dynamics of what's happening here. From my research, most of the refugees being deported are men. A lot of them are being deported because of crimes involving violence against women and sexual assault against children. Now, surprisingly, this case was handed down about a week ago in Australia, this second point. The judges just said this person had been convicted of child sexual assault in Australia, this refugee, and the judges just accepted, oh, he's a refugee. We have non-refoulement obligations to him. We actually don't. Anyone who has been convicted by final judgment of a very serious crime in their host country no longer has the benefit of non-refoulement under the Refugee Convention. But I think we need to have a really serious, as I said, thoughtful, nuanced discussion about the legal and normative aspect of this, what I think is a growing phenomenon. To make it clear, I'm not saying that these refugees should be deported. I just haven't done the hard legal and normative thinking about that. But I think in a lot of crimmigration scholarship on criminal deportation of refugees, the fact that the nature of the crimes that they have been convicted of is conveniently ignored. And I think I take my hat off to the person who tackles this subject, because they expose them, as I said, it's got to be done in a nuanced and sensitive way, and they risk exposing themselves to a lot of criticism and backlash. But as I said, I don't think we can continue to ignore it. The last thing I'll say, look, there seems to be a bit of a trend in crimmigration scholarship at the moment of looking at we should look more at the lived experience of crimmigration. And looking back on my own paper that was, published in 2019, not that long ago, I feel a bit uncomfortable with what I wrote in some ways. I used women's stories to critique this, what is really a Western theory of crime and criminalization. Now, these stories were in the public domain. From a formalistic ethical perspective, I did absolutely nothing wrong. But was I right to use these women's stories to build my argument? There is a push in the field of refugee and forced migration studies to really foster refugee-led research. And so as Magda mentioned, I'm building a project at the moment on refugees rewriting refugee law judgments. And I just wonder in crimmigration whether there'd be room for that sort of project, or even just more broadly, if there'd be room for critical reflection on the methods where scholars are using and the ethics of those methods. Because I think at the moment the field is scholars, mainly scholars from a non-refugee background, writing about refugees and migrants and not writing with them. So anyway, that's my reflections.
Thanks so much, Kate. Super fascinating. I think I'm just gonna stop the PowerPoint. Perfect. Marcia, do you want to open the floor? I don't see any questions.